Welcome back. Now that the eviction moratorium is over in Massachusetts, what should you do? If you're a landlord in Massachusetts, what do you do to collect your past due rent? Stay tuned for my tips and warnings about how to tread lightly. COVID has been a catastrophe to a lot of landlords and to a lot of tenants. Both have had issues that nobody ever expected. But now we have to face the consequences and find a solution to the housing crisis. If you have a non-paying tenant as a landlord, what do? Well, if they're still living in the property and you want them to continue to live there, you simply have to reach out, communicate, and reach out a payment plan. Whether they eventually pay you all the rent or you waive or discount the monthly rent, an agreement can be reached, and it's up to both of you to figure out what's the best choice. Obviously, giving people time will offer them an easier choice in gradually making the rent payments so that you both have an agreement. You have a paying tenant and the tenant has a place to live. If you do not intend to renew the lease agreement or the month-to-month agreement with the tenant, then we're dealing with an issue of simply wanting the property to be vacated. Most of the time, if the tenant has not paid, apart from any violations from the lease, you have the excuse of non-payment of rent as a reason to evict. I would suggest that you start with a 14 days notice to quit or notice according to your lease or rental agreement, and then follow through with the proper process of the housing court to initiate eviction proceedings. Stay tuned for my warnings about how to follow through correctly, because there are pitfalls to moving forward without proper legal advice. If the tenant has already vacated the property and you are simply left holding the bag with past due rent and possibly property damage, then the housing court is not the right place for you. You then are only worried about seeking monetary damages, lost rent, and the monetary damages for property damage. That's not even a housing court case. Your correct path is to follow through with a civil complaint for monetary damages, either through a small claim or civil complaint at the local or district court. Again, if you don't really know what to do or where to start, find help by reaching out to the court or simply hire an attorney that has experience and can handle the work for you. Everything has its costs, but you must weigh the pros and cons of whether it's worth following through. Each situation is different for every person, so just simply get informed so you can make a correct decision. If you're committed to following through with an eviction proceeding against a non-paying tenant, I give you the following caution. It's what we call counterclaims. A counterclaim is simply a tenant suing you for a violation, whether it's you failed to comply with the lease, whether it's a statutory violation where you entered the apartment without consent or authorization, or whether it is that the city, local, or state regulations require that you provide certain amenities or access to the tenant and you violated those rights. I caution you to inform yourself with a good lawyer or somebody that has experience dealing with landlord-tenant issues so that you don't go in blindly. What you may think is an easy case for a non-paying tenant could turn into a very difficult case where you end up paying the tenant for violations on your end. Now, there is a balance to this issue. As a landlord, you must be responsible for ensuring that the tenant has what you promised them: habitable housing and in compliance with city or local ordinance. As a tenant, you also must comply with the obligation to pay rent for, again, a habitable apartment in compliance with both local and state code. When the owner violates these duties in failing to keep up with the property, whether it's maintenance, repairs, or provide certain utilities and services, then the tenant has the right to sue the landlord. Few do that, but you can be assured that it's guaranteed to occur the moment you serve them a notice to quit. So, my advice, inform yourself of what right a tenant has to sue the landlord so that you know what to expect. It's the worst thing that can happen, going in blindly to a fight without knowing what to expect. And if you inform yourself, you can take care of a lot of those issues ahead of time so they're really not defenses in moving forward with the case. I will post a video about tenant defenses and counterclaims, and stay tuned for more.